Good morning. The time is 10 o'clock, and I call the June 6, 2024 Planning Board meeting to order. We have the following board members with us today: Commissioner Washington.
Good morning.
And Commissioner Dorner. And I'm Vice Chair Bailey. We now move to forward the business at hand. We move forward the business at hand. Please note that the deadline for all participants' pre-registration and for all submissions of materials and exhibits was due 12 noon on the Tuesday before this planning board meeting. Registered speakers may join the meeting with the link provided in the email provided by the planning board office or listen by phone by utilizing the call-in number provided in the email. Of course, anyone may tune in to watch the planning board meeting by live stream. If you wish to speak or become a personal record, you may use our online web form on the screen. In addition to the commissioners, we're joined by David Warner, our principal counselor, Jessica Jones, planning board administrator, Joe Pearsons, a senior technical hearing writer, editor, Parsons, James Hunt, division chief, he is now the deputy director. Staff member Kenneth Flanagan will guide us through the exhibits. And Ryan Crum is our technical guru behind the scenes. Our order of cases. We'll do 2, 4C, 4D, and 4E, 5, 6, 7, 8, 9 have been removed. And we now need a motion to approve the draft minutes of May 30th, 2024.
Move approval, Madam Chair.
Second. We have a motion and a second to approve the draft minutes of May 30, 2024. Commissioner Washington.
I vote aye.
Commissioner Dorner.
Vote aye.
And I vote aye. Motion approved. We have no legislative updates today, and let's look at the consent agenda. Is there anyone who wishes to oppose the staff recommendation on items number 4C, 4D, and 4E? Is there any board member who wishes to discuss any of these items?
After consideration,
I'll entertain a motion.
After consideration of the record for items number 4C, 4D, and 4E, I move adoption of the staff findings and approval of the items on the consent agenda in accordance with staff.
Second.
We have a motion and a second. Commissioner Washington.
I vote aye.
Commissioner Dorner.
Vote aye.
And I vote aye. Motion to approve. The planning board will be conducting an evidentiary hearing in this case regarding those intended to provide testimony to take an oath. At this time, I'm asking all persons intended to provide testimony to raise their right hand. Are there any individuals here on this case? Okay. Anyone else? Do you solemnly swear? This is item 5. Any individual who's here to testify on this case, would you please raise your hand? Do you solemnly swear or affirm that your testimony will be the whole truth and nothing but the truth? I thought there was several people here to testify on this case.
Madam Chair, this is Robert Antonetti, the attorney for the applicant. The applicant's team is here. They're only here to answer any questions, but they're not going to provide any direct testimony unless otherwise prompted.
Okay, thank you. All right, then we'll go to staff then. Mr. Eddie Diaz-Campbell.
All right. Good morning, Madam Vice Chair and members of the board. For the record, I'm Eddie Diaz-Campbell, Planner 3 with the Subdivision Section. Item number 5 on the agenda is the preliminary plan of subdivision for Spacemaker Self-Storage, 4-24008. The subject project proposes 2 parcels for the development of 137,115 square feet of industrial development. The application is subject to approved certificate of adequacy ADQ-2024-002. No citizens have signed up to speak on this application. Staff received 2 exhibits from the applicant prior to the noon deadline on June 4, 2024. The first exhibit is a requested revision to conditions of approval recommended by the technical staff report. Staff agrees with the requested revision. The second is a stormwater management concept approval letter for the project. Staff recommend adoption of the findings of the technical staff report and approval of the preliminary plan of subdivision 4-24008, subject to conditions contained in the staff report, as modified by applicant's Exhibit 1. This concludes staff's presentation.
Thank you. Thank you very much. We have Attorney Robert Antonetti.
Good morning, Madam Vice Chair, members of the Planning Board. For the record, my name is Robert Antonetti with the law firm of Shipley & Horn, here today with my partner, Arthur J. Horn, and we are pleased to represent the applicant in this case regarding Spacemaker Self-Storage. The applicant is Layton Warehouse, LLC. We do have representatives from the applicant and our development team to answer any questions. I would like to thank Mr. Diaz-Campbell for his review, his presentation, and his recommendations. He always does an excellent job on these subdivision applications, and today is no exception. As you're aware, this application is for a preliminary plan of subdivision as outlined in the staff report. What it essentially does is takes the existing development in this industrial piece of land, in this industrial park, and looks to repurpose the existing building and propose a second building for a future consolidated storage use. There will be a detailed site plan in the future that will show the exact, all the particulars that go along with the detailed site plan, which will come before this planning board. So we look forward to presenting that if this application is so approved. I would mention that we do agree with the staff's recommendations and findings and conditions, with the exception of the applicant's Exhibit 1, which Mr. Diaz-Campbell mentioned, where there was one small revision change to Condition 4B, which staff and the applicant are in alignment on. But other than that, we are in agreement with the staff's recommendation. We appreciate your consideration of this application, and our team is here to answer any questions that you may have. So thank you very much.
Thank you. And we do have additional backup exhibit items received. Item 5, AE1 PPS 42408, revised conditions, 1 page. Item 5, AE2, concept letter 36443-2024 SDC, 3 pages. And we have several individuals who are signed up to speak, and let's see if those individuals are here. Matthew Madolman, Dr. Horton, Hunter Gilbert, Tim Layton, Layton Warehouse, LLC, Michael Linhart, Linhart Traffic Consultant, Jim Layton, Layton Warehouse, Scott Wolfel, Collier Engineering and Design, Logan Alomar, Hollanders Engineer and Design, Arthur Horn, Shipley and Horn, John Verrietta, Shipley and Horn. Let's see, are there those individuals here? And I don't think we need to have you take an oath, but let's see, are you prepared to speak? Is Matthew available? Matt available?
Vice Chair Bailey, this is James Hunt for the record. I believe these folks that are registered are with the applicant's team. I think Mr. Antonetti can refer back to that, but if I recall correctly, these folks are with his team, so I think we are complete with that part.
Yes.
So we don't need to have any of those individuals speaking, okay?
I believe that's correct, unless you have any questions of them specifically. But we'll stand down and unless asked for further information.
Okay. Do we have any constituents who wish to speak on this item? Seeing none, then we will entertain a motion.
Madam Chair, I move that we adopt the findings of staff and approve preliminary plan 4-24008 along with the conditions as outlined in staff's report and is further amended by applicant exhibit number 1.
Second.
We have a motion and a second. Further discussion? We have none. Commissioner Washington,
I vote aye.
Commissioner Dorner,
Vote aye.
and I vote aye. Thank you.
Thank you very much.
We're now moving to the preliminary plan of subdivision 42409 Kenilworth Interchange Industrial Park, item 6. One person has registered, Don Smith, registered speaker, may request a continuance of this case to provide him with additional information to review the staff report. Is Mr. Smith available?
Yes, I'm here.
Okay.
So, thank you. So, I'm here to request a postponement of this matter. I think we have a rather unique situation, and it is unclear to me whether, well, there are several items I think that are missing from the materials that are available for public review. I think we have a unique situation in this case. There's many transitions occurring right now in the county regarding regulations, floodplain delineation, and we need to ensure that we've got full and complete information. Is the floodplain delineation using the current standards, some of which have been only...
Just a minute, sir. Excuse me, I do apologize, but I need to ask for directions and guidance. Do we need to entertain an oath before we ask him to continue?
Madam Chair, David Warner, Principal Counsel. Mr. Smith is asking for a continuance. We haven't opened the hearing yet. He should just limit his remarks to why a continuance, he's calling it a postponement, but I think he means continuance, why he thinks a continuance is appropriate, and then the planning board can entertain his request. But he shouldn't get into the substantive issues. If you don't grant the continuance, then we will hear the substantive issues, and he can talk about those at that time. But right now, he should just limit his request to, or his comments to, why a continuance is would be appropriate in this case.
And so we don't need to do an oath at this time.
Not at this time, not until you open the hearing.
Thank you very much. Continue, sir.
Thank you. And I'll try to do that in some of these cases. It's not easy for me to distinguish between the, that. So I do understand that if the continuance isn't granted, that you can present, fuller information during the hearing. But for the moment, just like to paint a quick picture. So we have a property that today has conditions that have been, I guess, quite different because of some, what I would say would be illegal, certainly unpermitted actions by the owner that have not been fully put on the record. And these bear on, I think, the action that would be taken by the board. So we have floodplain. It's unclear the extent to which we have floodplain. We definitely have floodplain, that's admitted. We have impaired floodplain, impaired by this owner through unpermitted uses. And we have incomplete, for example, there is apparently a slope stabilization and geotechnical report that was apparently done. It's referred to. It's not available for review, and that and the fact that we have, we've had significant removal of trees, and we have a assumption or an assertion that a credit purchased 22 years ago is applicable today for the forest mitigation. So we also, to me, this has bearing. The circumstances are further clouded, I would say, by this transition from the new ordinance to the old ordinance. We clearly understand that the old ordinance, there's circumstances when that is available and is can be used by applicants. I get that. In this case, though, it's been stated that the new ordinance, this project would not be feasible under the new ordinance. And it would be, I would like to know from, I think it should be in the public record, why that is. And has that, so for a number of reasons, it's important that the record be complete and accurate going forward. And I don't believe that it is, and that with more time, we could do that. And just, to make clear, the applicant waived the timetable for review by the board. So I believe it says in the documents you have till the deadline now is not until September or something. So therefore, this is not the normal deadline. So it would not be out of order or an exceptional measure to take a little more time to gather this information so that we can have a full record and reasoning for your review. Thank you.
Thank you. And let me now turn to the commissioners to get their reaction regarding this request.
Madam Chair, if we could hear from the applicant, I believe it's in order for the applicant to respond, and then we can deliberate.
Okay.
Correct?
Thank you.
Mm-hmm.
Thank you. Good morning. Thank you. Good morning, Madam Vice Chair, members of the board. Thomas Haller on behalf of the applicant and the owner of the property. I do want to say at the outset that we would not support continuing this case. And I wanted to provide the board just a little bit of background with regard to some of the prior communications with representatives of the community. As you know, we're required to send out notification letters as part of the development review process. In this case, the first letter that we sent out was in January 11th of 2024, prior to filing a site development concept plan for this property. That letter was sent to registered civic associations, and we were contacted by the Cheverly Green Infrastructure Committee, of which Mr. Smith is a part. And the chairman of that committee, Ms. Sallow, contacted our engineer, who forwarded her information to me in early February. And I contacted her to let her know that we would be happy to attend a meeting of the Green Infrastructure Committee, which we did on March 5th of 2024. In response to that meeting, we submitted a copy of documents. We provided a copy of our preliminary plan as well as a copy of our site development concept plan. And the one issue that was raised at that meeting, or one of the issues that was raised at the meeting, we talked about stormwater management and how we were handling that. But one of the issues that was raised was a question about the clearing of the property that had occurred. And they asked us if we would revise our plans to show that the property was fully wooded. In other words, to treat the property as though it was fully wooded, because they were not aware of any permits that had been issued for that clearing. And so we indicated that we would look into that and investigate that. because our original tree conservation plan only reflected the existing trees on site. Through talking to your staff through the environmental planning section, when we got to subdivision review committee, they confirmed that there had been a prior approved tree conservation plan for this property. And we also determined that woodland mitigation had been acquired to conform to the requirements of that prior tree conservation plan, but that because some of the trees were removed, or because the trees were removed without a permit, that they would require this application to treat the property as though it was fully wooded. And so we did in fact do exactly what we were requested by the Green Infrastructure Committee. And I subsequently informed Mr. Smith that we were going to do that, that there had been a prior approved tree conservation plan, and that the mitigation had already been acquired for most of the tree disturbance. The other documents that Mr. Smith has asked for, he has not requested that we provide copies of those documents to us. We were requested prior to filing the subdivision application, prepare a geotechnical report and a slope stability study, which we did. That's been in the record since the day that we filed the application. And we have also obtained approval of a site development concept plan. And as part of that, as reflected on the site development concept, as reflected on our natural resources inventory, we have an approved floodplain delineation by DPI that was approved on July 28th of last year. So we have provided all of the documentation to staff, and to the extent that Mr. Smith would like to look at those documents, he has not asked us for any of those documents, and we've been engaged with him and the Green Infrastructure Committee for several months now. And so my understanding is that the letter that was submitted requesting the continuance was submitted into the planning board after the deadline, and there's been plenty of opportunity to obtain any information or documentation that they would like to see with regard to these plans. And most of the plans that he's seeking are plans that are reviewed by DPI. They're not necessarily plans that are reflective of the subdivision. And my final comment is that the work that we need to do to bring the property into full compliance with all code requirements requires approval of this preliminary plan of subdivision. And so we don't want to delay approval of this preliminary plan, because we would like to be able to do the work and get the permits that are needed to bring it into full compliance. And I'm happy to answer any questions that you have.
Thank you, Mr. Howell. Before we continue, Mr. Bartlett, is there anything that you would like to add to this? I do apologize for not calling on you earlier.
Yes, Madam Vice Chair. I have the presentation that I would normally present whenever the appropriate time comes. I'm ready to present that.
And also, sorry, Vice Chair Bailey, there's no additional information from our side. So for staff, it's truly dependent on how the board wishes to proceed at this point. If they want to entertain the continuance, or if they do want to pursue today's hearing, we're ready to go either way.
Thank you very much.
Madam Chair, question. Mr. Howler, in his commentary, indicated that the letter of request for continuance came in after the deadline. I would ask staff to please comment on that. And if in fact that is the case, I would ask Council Warner if in fact we should be even considering a continuance.
This is David Warner, Principal Counsel. I can answer that. Yes, we received a letter requesting a continuance on Wednesday. So when you receive a document after noon on Tuesday, we can't entertain the document. But Mr. Smith had signed up to speak, so he's free to request the continuance, which is what he's doing. And then I'll also add that because I had a chance to look at the letter, and now I've heard Mr. Smith's comments, which to me look more to the substantive issues and not, any kind of deficit in notice or inability to see the documents. We at legal always, of course, review all of the staff reports before they come to you. So when we reviewed this staff report, we saw all of the documents necessary to support the applicant's recommendation, or the staff's recommendation. So to the extent any documents he thinks might be missing, we did not see that when we reviewed the application.
Thank you.
Are there any other questions or comments?
May I just answer a couple of points that were made regarding my request? And that is that.
Just a minute, please. We're under staff deliberation at this point, and I'll come back to you later in a minute. Just in a minute. Any other comments from staff or commissioners? Okay, we will entertain a comment, a very quick one.
Yeah, just that the many of these issues really were not, and even the documents and were not made available until last Wednesday. So it's only been like 8 days and over the Memorial Day weekend. So the issues of the extent of the floodplain and all this stuff was not, we have not had a full and robust period of time to review everything. And as I said, not all of it is even available.
Okay. Thank you, Mr. Smith. I'm totally out of order. I'll go back to the staff. The commission is under deliberation at this point. Any other comments?
Madam Chair, David Warner, Principal Counsel, just in response to that comment, just for the commissioner's information, the staff report and all applicable documents were posted online pursuant to the Planning Board's rules of procedure. So this application, as far as being the information being available to the public, was all published in accordance with the Planning Board's rules.
Okay, commissioners, your position on entertaining or the request?
Madam Chair, I move that we deny the request for continuance for preliminary plan 4-24009.
Second.
All right, we have 3 votes to deny the request for the continuance. Commissioner Washington?
Oh, yes, I vote aye. I vote aye.
Commissioner Warner? I'm sorry.
Commissioner Dorner votes aye.
Dorner, yes. And Bailey? I vote aye. The request has been denied. So let's move forward with the hearing. The planning board will conduct an evidentiary hearing in this case, requiring those intending to provide testimony to take an oath. At this time, I ask all persons intending to provide testimony to raise their right hand. Where are the individuals who are here to provide testimony? All right. Do you solemnly swear or affirm that your testimony will be the whole truth and nothing but the truth?
I do.
Okay. Thank you. Let's go back to staff now. Mr. Bartlett?
Good morning, Madam Vice Chair and members of the board. For the record, I am Jason Bartlett with the subdivision section. Item number 6 on the agenda is a preliminary plan of subdivision for Kenilworth Interchange Industrial Park, case number 4-24009. The subject project proposes 1 lot for 15,000 square feet of industrial development. This application is also subject to an approved certificate of adequacy under case number 80Q-2024-011. Staff has received 2 items of additional backup from citizens, which will be addressed further in this presentation. Next slide, please. The site is located in the northwest area of Prince George's County within the town of Cheverly. Next slide, please. The site is located on the south side of Lindell Road, approximately 850 feet east of the intersection with Kenilworth Avenue. Next slide, please. The property is in the industrial employment IE zone. However, the application has been submitted and reviewed under the applicable provisions of the Prince George's County zoning ordinance and subdivision regulations effective prior to April 1 of 2022 under the prior zoning ordinance. The site was in the light industrial I-1 zone, which is used for this analysis. Next slide, please. The property is located in an existing developed industrial park. Next slide. The site map shows the property slopes downward to the south. Next slide, please. The property fronts on Lindell Road, a primary roadway to which access for the site will be provided. Next slide, please. This is a closer image of the site. The property is partially graded and contains various stored materials on site. Staff has received 2 items of additional backup for this case related to this clearing, both of which are letters from concerned citizens either residing in the neighborhood of the proposed development and or who have interest in the neighborhood through an association, group, or club. Both have expressed concerns regarding clearing of the site that occurred between 2010 and 2014 without appropriate permitting or authorization. These concerns were also raised by the same individuals at the outset of subdivision's review of this case, which staff has addressed in the staff report on pages 14 and 15. The concerns noted in the letters submitted as additional backup provide comments and questions regarding the existing condition of the site. Namely, the citizens are seeking information on the clearing and use of the property that exists, whether it was permitted or would have been allowed to be permitted, any penalties or enforcement that should be assessed, and or any action which should be taken with this application. Staff conducted research and found no record of final permits having been issued for clearing or use of this site. Notwithstanding permits were not issued for the site, a contractor storage yard is a permitted use in the I-1 zone. The Department of Permitting, Inspections and Enforcement, DPI, is the authority on permitting and enforcement for the county, and any enforcement measures would be under their purview. DPI was referred this application, and staff did correspond with DPI enforcement concerning the existing conditions. DPI confirmed that the part of their enforcement measures, they would require an applicant to gain approval of plans necessary to come into compliance. The applicant, by filing the preliminary plan and tree conservation plan in this application, is following the process necessary to come into compliance with the requirements for site development. Accordingly, the existing condition of the site does not preclude the planning board from making a decision on this application. Next slide, please. This is the proposed preliminary plan of subdivision for one parcel. Access will be provided from Lindell Road. Next slide, please. The tree conservation plan shows the concept development. The site contains 0.04 acres of floodplain at the southernmost part of the site. Woodland conservation requirements are to be satisfied via an existing off-site woodland bank and fee in lieu. As part of the history of the site, although permits were not issued by DPI, a prior tree conservation plan was approved by planning for the clearing of the site, and the off-site woodland bank was secured in 2002. Evaluation with the current TCP was conducted in accordance with the current tree conservation requirements as if the site remained fully wooded. The off-site woodland credits purchased and provided previously and remain credited to this proposed development in addition to a fee in lieu imposed with the review of this PPS. As a part of the citizens' letters in the additional backup, concerns and questions were also provided regarding where the woodland credits / bank were provided and where the fee in lieu would be used. The existing woodland bank is located in in the Old Fort subdivision, which is located in Fort Washington and is now fully planted with a full tree canopy. The tree bank remains in conservation and protection under an easement. Regarding the fee in lieu, fees are collected by the county and are administered by the Prince George's County Department of the Environment, or DOE. Next slide, please. The primary management area on site consists of 0.04 acres of floodplain, which is currently impacted by the activities which have occurred on site. The impact area is proposed to remain, however, as part of the development of the site, the existing pavement will be removed and stormwater management features will be located in this area, along with a sewer connection to an existing off-site sewer line in the PMA. The staff finding for evaluation and recommendation of approval of this impact are included on page 27 and 28 in the backup and will be incorporated into the resolution. The applicant will also be subject to current stormwater management requirements for development of the site and has obtained the approval of stormwater management concept approval from DPI. Next slide, please. Staff concludes that the applicant has met applicable provisions of the subdivision regulations, zoning ordinance, and woodland conservation ordinance for the purpose of approval of this application. Subdivision staff recommend that the planning board adopt the findings of the technical staff report and approve PPS 4-24009 for Kenilworth Interchange Industrial Park and Type 1 Tree Conservation Plan number TCP 1-016-2024, subject to the conditions contained in the staff report and the additional findings for approval of the primary management area impacts contained on page 27 and 28 of the backup. This concludes staff's presentation.
Thank you very much. Let's now turn to Mr. Haller. Are there any comments?
Thank you once again, Vice Chair Bailey and members of the board. Thomas Haller again on behalf of the applicant. I do want to note at the outset that we are in full agreement with the staff report and with the staff's recommendation in this case. And we appreciate the efforts in terms of working with Mr. Bartlett as well as with the environmental planning section to address all the issues that have been raised. I do want to provide a little bit of background. The applicant in this case also owns the property that abuts the subject property to the south. So if you look at the aerial photograph that is before you, the very southern tip of this property abuts land that fronts on the adjoining Schuster Drive. And my client occupies a portion of that building. He's occupied that building since approximately 2001 and was able to acquire that property and this property back in 2010. And then after he acquired the property, as his business began to expand, he ended up storing some items on the property that he owned in the rear. But as noted, even though there was a prior approved tree conservation plan, in fact, there was a grading permit that was applied for and approved, but then later abandoned by a prior development application. There wasn't a subsequent grading permit that was issued specifically for that impact that was done by the applicant in this case. But my client is now looking to utilize the property in a broader scope, and as part of that effort is required to go through all of these approvals. And as staff said, they essentially did a reset and said, we're going to treat the entire property as though it's wooded, and you will be and we'd be required to conform with all current regulations. Because the property was previously the subject of an approved tree conservation plan, which, by the way, we weren't aware of that tree conservation plan because there was a mapping error in dams and it had the tree conservation plan associated with a different property. Your staff brought that to our attention, and it was when they did that that we determined that we did need to treat this property as fully wooded. And so when that plan was approved, there was, in conjunction with a prior development proposal for the property, the offsite mitigation was acquired, as Mr. Bartlett indicated, and the tree conservation occurred on a former sand and gravel site in the old Fort subdivision. And so the only remaining tree mitigation that's required in relationship to this development, which is now being reviewed under current regulations, is 0.09 acres of woodland conservation, which is less than 4,000 square feet. This applicant will complete those requirements. And in addition, prior to filing the subdivision application, my client obtained approval of a site development concept plan, again under current ESD requirements. And as part of the development of this property, we'll be installing appropriate stormwater management devices, which include quantity treatment of the 100-year floodplain condition. So this property, as it moves forward, will now be in conformance with all current requirements, and the work that's done in order to implement this subdivision will address any prior grading on the property and as well as the remaining tree conservation. So we do believe that we have moved forward appropriately. Your staff has done exactly what your staff should have done. They were able to look at the old records to determine what needed to be done to bring the property into full compliance. They have informed us of those requirements. We are conforming to those requirements, and we need approval of this subdivision in order to be able to move forward with the development. The final thing that I would like to note is that this property, and Mr. Bartlett mentioned this earlier, it's really the last undeveloped parcel within a larger industrial enclave that consists of about 45 acres of land. And you can see all of the other properties are fully developed. This property did not develop previously because it does have topographical challenges, and those are being addressed through the development of the property. But even though the property was previously subdivided and is a subdivided lot, because it was subdivided prior to 1970, any new development of greater than 5,000 square feet requires the approval of a new preliminary plan of subdivision. And that's why we are required to go through this process in order to develop the property as proposed. So just to provide a little bit of additional background information. So again, we agree with the staff's findings and recommendations, and we request the planning board approve the subdivision as submitted. Thank you very much. I'm happy to answer any questions.
Thank you. Are there any questions? Commissioners, we do have Mary Reed, from our department, who is our environmental expert, if you have any additional questions. We also have additional backup exhibits received. Item 6, RE14711 Lindell Road, 42409 Silo email. And item 6, RE2 PPS 424009 comments FLBC 060624 page 1. Are there any additional questions? If not, we do have a speaker, and that is Dan Smith, Friends of Lower Beaver Dam Creek. Mr. Smith, are you here?
I am here.
Okay, thank you.
Thank you. And first, I do want to thank the planning staff and for taking our, it was myself and those of us in the community that identified the tree loss on the site. We took the initiative to do some research, looked at the PG Atlas. It was no professional staff, people paid to do this, that found this. It was people in the community working as volunteers who identified this and brought it to the attention. We brought it to the attention of the staff. I don't think it really even got elevated until I participated in the review by the agencies, which was a first for me. I've not done that. It was, but one of the things that really did not come out as well was the floodplain condition. And so I would like to say that I think we don't have a full, complete record about the floodplain determination. My look at and understand that PG Atlas there's some disclaimers. This isn't the legal delineation of everything of things. It's a tool and a guide. It was very helpful to determining the tree cover, for example. But in the case of the floodplain, when I look at the DPI floodplain delineation on PG Atlas, and as I mentioned, there have been a number of changes and an increase in the standards of how floodplains are delineated due to the changing climate and the increasing amount of rainfall we're getting has changed significantly in recent years, the understanding and the requirements. So it's unclear to me, because some of these requirements by DPI were to go into effect as recently as February 1, whether we have the full accurate picture here. When I look at that, the site, 12% of the site is floodplain. Now, I believe according to the documents that you are reviewing, it's just about 2.5% of the site. So that's a significant difference. And it would seem to me it would make a difference. None of the reviewers took into consideration, which to me is important, that the floodplain area there had been in natural state and function prior to this applicant's actions. So the applicant, while I guess I would accept that whatever compliance, standards that they're bringing that up to standards, it's still important to understand. We would be in, I think, a really different place today looking at this site and the opportunity to develop it in an environmentally friendly way. We'd be in a different place. I'm not opposed to the development. I'm saying we would do it differently if we were looking at a site that was 100% forested, which is what it was when this applicant bought it in 2009. They then proceeded almost immediately to clear what turned out to be 62% of the site and use it for a purpose that was not, even though it may be allowed, was not permitted. There was no stormwater management put in place. So therefore, the wetland was impaired, destroyed its function. The stream immediately adjacent to the property is significantly impaired by this use and by other factors. Significantly impaired. Immediately downstream through the industrial park immediately downstream, Tuxedo Road and Route 50 have had chronic flooding during this period of time. I'm talking serious flooding. They have been shut down entirely. We have had search and rescue teams come into the Route 50 to rescue commuters from their cars because of this. We have had a constructed wetland trying to remediate this right between Route 50 and Tuxedo Road, an area that was built using public funds from the mitigation of the Woodrow Wilson Bridge. So it'd be 15, 20 years ago. That has been rebuilt at least completely 2 times because of flooding. So what I'm saying is that we're not taking seriously enough in the development review process the circumstances of tree clearing, floodplain impairment, and climate change. And I understand you are limited in certain, constraints of your decision making, but it is imperative to look at the big picture. And in this case, this applicant was making the situation worse during the same time our county has been spending hundreds of millions of dollars, hundreds of millions every single year to retrofit areas like this parking lot that they've been using, retrofitting those areas for hundreds of acres to get stormwater management. That is under federal guidance, cooperative agreements, law. It is not insignificant the amount of fees every property owner pays for this. At this time, so during that period, this operator, I just don't understand how it could be claimed that they can be let off the hook and be in compliance after having made this situation worse while we're cleaning up the mess from the previous inadequate development practices that we have had. So this is not a question of not understanding the impacts and the seriousness of. We know that this is going on. So if this was 100% forested, we could have come up with a plan that would allow the development, maybe not as big a footprint, but it could have significant contribution to the economic viability of this part of the community. And we could have had some natural green infrastructure using the floodplain and gray infrastructure combination. So we don't have that. So we're here today, and I have to say that thank you for the information about the mitigation banks. This is the very first that has been presented and available for review. But I still just think there's it just does not seem right that a mitigation bank funding 22 years ago by a previous owner for a different permit and things would be able to compensate for the tree conservation needs and requirements of this application. And so I was asking for the continuance because it very well may be that given this condition that the stormwater management, the rainwater capture, and the underground wetland, that very well may be of a capacity to handle what is going to be generated from that site. But I don't think that we really, I don't have confidence. I don't think that the record shows is documents that it really does, and that we need to ensure that it is the highest standard of for capacity for trying to treat that stormwater. And just the other thing that the record did not adequately show that this property is, and the forest on it is contiguous with important other forest woodlands in the area. It is critically important for the stream that's highly impaired. And immediately across from that stream is park and planning property, the Cheverly Euclid Woods Park area, and the Cheverly Swim and Racket Club. And the woodlands there, I just would say, is also identified as a critically important hub of natural area central to the Cheverly Green Infrastructure Plan, which was adopted by the town like 15 years ago or 11 years ago. So some of that was not, and it is also the Green Infrastructure Plan of the county shows this as a area for evaluation. So that was not clear in the record as well. So I just want to, and it's finally, I guess, in closing, I would ask that my letter sent yesterday be entered into the record as an extension of my remarks today, so I don't have to sit and read it or something, but I would, because it has a few other points, but I'd say it's important that the record reflect this and that we find ways to appropriately bring these concerns into the development review process, because pick up the paper today, record-setting temperatures in the last year, record rainfalls, and it's just continues to be very disappointing, the lack of leadership in this county to address these critical issues. And the more we continue to use old models of development, the bigger the burden for future generations. Thank you.
Thank you very much. Mr. Howard, do you have any additional, let me go to staff first to see if staff has, if you have any additional comments. If not,
No, Madam Chair, we do not.
thank you. Mr.
Good
Howard.
morning, Madam Vice Chair. This is Sherry Connor with the subdivision section. If I could just offer a couple of comments. As Mr. Bartlett pointed out in his presentation, the enforcement of any use or clearing of the property is under the authority of DPI, and any, as introduced by Mr. Haller as well, this is one of the steps in, coming into compliance as part of any enforcement action that would be undertaken by DPI. Regarding the floodplain delineation comments, I'm not real sure where the 12% figure came from that Mr. Smith spoke about, if that is a rough estimate based on PG Atlas mapping. Again, that the disclaimers on the PG Atlas website do say that the graphics thereon are for informational purposes only, and they are not to be used for official purposes. In this case, the floodplain delineation was approved by DPI. That same delineation is reflected on the stormwater concept, as is reflected on the NRI approved for this site and the tree conservation plan. Section 24-129 of the subdivision regulations sets forth the requirements for floodplain in the review of a subdivision. It essentially requires that one, floodplain be delineated on the plans, and it has been. And two, that if the area of the floodplain is used, is necessary to be used, it may be used for utility lines, storm drainage facilities, passive areas, things like that. In this instance, restoration of that area is being done. It will be used for stormwater management in that area, as well as a utility line connection. There's an existing sewer line that runs in the floodplain that is off-site. It used to be common practice to place sewer lines in the stream bed. So I just wanted to point a couple of those things out to the board. Thank you.
Thank you, Ms. Connor. Now we go back to Mr. Howard.
Thank you, Vice Chair Bailey. Again, Thomas Heller on behalf of the applicant. I just wanted to expand a little bit on what Ms. Connor just said and just note, and as I think I mentioned it earlier, but we do have a site development concept plan approved in this particular instance. Typically for a preliminary plan of subdivision, the ordinance states that we have to at least show evidence that a site development concept plan has been filed before the preliminary plan of subdivision can be accepted. In this case, we have an approval of the site development concept plan. And I wanted to note that in order to obtain approval of the site development concept plan, the Department of Permitting, Inspections and Enforcement requires that if there is any floodplain, that an analysis be done and then it be delineated. And the site development concept plan conformed with that requirement. In fact, there's and we are also required as part of our natural resources inventory to identify and delineate any floodplain, which was done. And there's a note on the natural resources inventory that the Department of Permitting, Inspections and Enforcement approved the delineation of a floodplain as is shown on the property pursuant to a report that was approved on July 28th of last year. So this is a current floodplain delineation. And as Ms. Connor noted, when you look at PG Atlas, if you put on the floodplain layer, you'll see a shaded area. And that shaded area provides you information that there may be floodplain on the property, but it isn't an exact delineation. And so you need the exact delineation to understand what the actual impact is. I would also note there is a stream that runs north and south just to the east of the property. And you can see where the property is outlined on the aerial photograph in front of you. And there's a kind of a linear area that runs north and south adjacent to it. There is a stream that runs along that area. And, most of the development in this area, as you can imagine, was constructed before current regulations. There are some pipes in under the roads and that convey that stream that are somewhat undersized, and they result in a backwater of the floodplain condition. And so that's what impacts the southern part of this property. But notwithstanding, we have delineated that floodplain, and that floodplain is being accounted for as part of the development of this application. The other thing I wanted to note, Mr. Smith indicated that there wasn't any indication in the record that the stormwater management would be was going to be adequate. But that's why I noted that the stormwater management concept plan is actually approved. It's not just a proposal. It's not just an application. It's actually been approved by DPI. So I believe that is a fair indication that the methodology proposed in our site development concept plan is adequate to address the requirements, which include a requirement that the quantity controls on site handle the 100-year flood, which again is something that other developments did not do because other developments in this area largely did not provide much in the way of stormwater management because they were approved 50 years ago. And then the final thing I wanted to note was Mr. Smith said that this is in an evaluation area in the green infrastructure plan. And I would note that your staff report specifically notes that and then does a 4-page analysis of the conformance of the proposed subdivision with the green infrastructure plan. And so that is in the record. It is in your backup. It is in the staff report. And I think it adequately addresses any concerns related to conformance with the green infrastructure plan. So as Ms. Connor noted, in order for this property to be brought into compliance, the subdivision needs to be approved. This subdivision, not only the stormwater management, but the tree conservation is being evaluated under current regulations as though the property were fully wooded. So we've done everything we can to bring this property into conformance with regulations. So premised upon those points, we would support the staff's recommendation of approval, and I'm happy to answer any additional questions you may have.
Thank you, Mr. Haller. Commissioners, any additional questions? If not, further deliberation from commissioners then. Any questions? No questions, and we will entertain a motion.
Madam Chair, I move that we adopt the findings of staff and approve preliminary plan 4-24009 and TCP 1-016-2024 subject to the conditions as outlined in staff's report.
Second.
We have a motion and a second. Commissioner Washington,
I vote aye.
Commissioner Dorner,
Vote aye.
and I vote aye. Motion carries 3-0. All right, item 7.
Thank you.
We have Attorney Horn with us for item 7. This is preliminary plan of subdivision PPS 2023-024 Addison Park. We have a number of speakers signed up for this item, and we have Attorney Mr. Horn with us today.
Yes, good morning.
We have speakers on this item, and we'll first go back up to the staff presentation. Mr. Campbell is here.
Yes, good morning, Madam Vice Chair and members of the board. For the record, I'm Eddie Diaz-Campbell, Planner 3 with the subdivision section. Item number 7 on the agenda is the preliminary plan of subdivision for Addison Park, PPS-2023-024. The subject project proposes 4 parcels and 4 out parcels for the development of 293 multifamily dwelling units for the elderly and 29,572 square feet of commercial and institutional development. The application is subject to approved certificate of adequacy ADQ-2022-012. No citizens have signed up to speak on this application. All of the people on the sign-up list were members of the applicant's team. Staff received 1 exhibit prior to the noon deadline on June 4, 2024, which includes revisions to the conditions and findings of the staff report requested by the applicant. Staff agrees with the requested revisions. Staff recommend adoption of the findings of the second staff report, approval of a variation from Section 24-4205 of the subdivision regulations, approval of a variance from Section 25-122B1G, approval of Type 1 Tree Conservation Plan TCP1-004-2024, and approval of preliminary plan of subdivision PPS-2023-024, subject to conditions contained in the staff report as modified by applicant's Exhibit 1. This concludes staff's presentation.
Thank you very much. Attorney Horn.
Good morning, Vice Chair Bailey, members of the planning board. For the record, Arthur Horn, the law firm of Shipio Horn here in Largo, Maryland. Very pleased to be here this morning representing the Prince George's County Redevelopment Authority, represented by Mr. Jerry Conahue, who is on. The applicant's representative here from Cobra Johnson and Rodney, Mr. Harold Johnson, is with us. The civil engineer of SOTES, Mr. David Bickle. We have Linhart Traffic, Mr. Michael Linhart, and also our land planner from Shipio Horn, Mr. Andrew Shelley, is with us. As Mr. Eddie Diaz-Campbell and I, as usual, want to thank him for his thorough presentation, and he and his staff, as they work with us through this application process. The Redevelopment Authority is putting together a redevelopment of this area. And this particular application is looking at 293 senior housing units on parcel 1 and 4. And this is just the first step. The detailed site plan is coming in right after this. We made a couple, as Mr. Diaz-Campbell indicated, a couple of variation requests in there. And I think we made the criteria set forth in the staff. The development and proposal by the Redevelopment Authority is consistent with the master plan, general plan, and all in that area. And we just asked the planning board for their favorable consideration and adopt the recommendation along with the applicant's Exhibit 1, which is just slight modification, which I could go into in detail if you like. But it just basically deals with some administrative changes, word changes.
Thank you, Mr. Horn. Commissioners?
No questions, Madam Chair.
No questions? Then we will entertain a motion.
Madam Chair, I move that we adopt the findings of staff and approve preliminary plan PPS-2023-024, TCP1-004-2024, variation from section 24-4205 and variance to section 25-122B1G, along with the conditions as outlined in staff's report and is further modified by applicant exhibit number 1.
Before seconding the motion, I may have missed it, but did we ask if there were any other speakers that were signed up that we needed to have provide testimony?
Well, staff indicated that the speakers who had signed up were with the applicant's team.
Right.
And there were no citizens who signed up, so.
All right, I'll second the motion.
Okay. I vote aye, and motion carries. Thank you very much.
Thank you very much.
Thank you.
Okay, we're now at item 8. Specific Design Plan, SDP 2303, Dobson Farms.
Madam Vice Chair,
Yes,
on that last case, I don't think we actually took a vote. I know you voted, but I don't think I just seconded the motion. I don't think Commissioner.
You're correct, Commissioner. Thank you.
You just I do apologize. You can see that I tried to move it on. Let's go back there. Thank you. All right, so let's do it all over again, Ms. Washington, if you don't mind, so that we can have it correct appropriately.
You want me to do the motion again?
Yes.
Okay, no problem. Madam Chair, I move that we adopt the findings of staff and approve preliminary plan PPS-2023-024, TCP 1-004-2024, variation from section 24-4205 and variance to section 25-122B1G, subject to the conditions as outlined in staff's report and is further modified by applicant exhibit number 1.
And I'll second that.
Okay, we have a motion and a second. Ms. Washington.
I vote aye.
Zadorna.
I vote aye.
And I vote aye. Motion carries. Thank you very much. All right. Let's now go to item 8. Specific Design Plan, SDP 2303, Dobson Farms. We have attorney Matt Tedesco is with us. And, okay.
Okay, good morning. Madam Vice Chair, can you hear my sound?
I can hear your sound, but let me just read this before we start there. The planning board will be conducting an evidentiary hearing in this case, requiring those intended to provide testimony to take an oath. At this time, I'm asking all person intended to provide testimony to raise their right hand. Do we have anyone providing testimony?
Madam Vice Chair, we have a number of folks on the line on behalf of the applicant. I don't anticipate they will, but in the abundance of caution, I'll have them queue up and take the oath if that's okay. I think we have one citizen who should also probably take the oath.
There's a Kabita Gray. Is that person here? Is that Mr. Gray or Mrs. Gray?
They're showing as logged in.
I'm sorry.
They are showing as they are logged in. They're just muted. There you go.
It's Kamita Gray.
Is Mr. Gray?
No, it's Miss.
Mrs. Gray?
Yeah.
Okay, then we do need you to take the oath then. Do you solemnly swear or affirm that your testimony will be the whole truth and nothing but the truth?
Yes.
Yes.
Thank you. All righty. Now we will go to staff.
Good morning, Madam Vice Chair Bailey and members of the Planning Board. For the record, I'm Emery Huang with Urban Design Sections. Item number 8 on the agenda is Specific Design Plan SDP-2303 titled Dobson Funds, which proposes infrastructure improvements including public streets, water, sewer, storm drain utilities, and storm water management facilities. The applicants has submitted a variance request to remove 21 specimen trees. The steps analysis of this requested variance can be found on pages 13 to 15 of the report. Steps support the removal of the 19 specimen trees, and the remaining 2 specimen trees will be evaluated with the preliminary plan of subdivision. The applicant also submitted a request for 27 PMA impacts. The steps analysis of this request can be found on pages 15 to 16 of the STEP report. Steps support 25 PMA impacts, with the remaining 2 to be evaluated at the preliminary plan stage. As a matter of housekeeping, the applicants also provided a revised conditions memorandum titled Applicants Exhibit 1 prior to the June 4th noon deadline. STEP has reviewed all revisions submitted and are in agreement with the proposed changes. In addition, STEP has also received 2 letters of opposition from the Brandywine Southern Region Neighborhood Coalition, titled Opposition Exhibits 1 and 2, respectively. The items of concerns were regarding various impacts, specifically regarding public facilities, traffic, and air and water pollution. However, issues raised are not relevant to this SDP, since the subject application is for infrastructure only. Traffic and public facilities adequacy will be evaluated at the preliminary plan of subdivision stage. Development aspects of the residential subdivision, such as architecture and landscaping, will be evaluated at the full specific design phase. In conclusion, STEP recommends the Planning Board adopts the findings of this report and approves specific design SDP-2303 Type 2 Tree Conservation Plan TCP2-00A-2024 and variance from Section 25-122B1G for the removal of 19 specimen trees, subject to the conditions found in the STEP report as revised by the applicant's Exhibit 1. This concludes STEP's presentation. Thank you.
Thank you. Thank you. Thank you very much. Mr. Tedesco?
Good morning, Madam Vice Chair, members of the Planning Board. For the record, Matthew Tedesco with the law firm of McNamee Hosey here in Greenbelt on behalf of the applicant DR Horton Incorporated. Represented this morning by Mr. Matt Muddiman. We also had members of our team from Rogers Consulting, Mr. Alex Villegas, Matthew Lakin, who is our expert land planner, landscape architect, as well as Christine Gillette, who's an expert landscape architect, Charlie Howe, expert engineer, Steve Allison, who's our expert arborist and environmental consultant, as well as Rob Swam, who is our environmental consultant from Rogers Consulting. In addition, we have Michael Lenhart from Lenhart Traffic Consulting, who is our expert traffic engineer. I certainly want to take a moment to just thank Mr. Wong and for his review, as well as Ms. Garland and your entire staff, in particular your urban design staff, transportation planning staff, and environmental planning staff. We've worked very closely with them for a number of years now on this project in particular, but more recently as it relates to this infrastructure SDP. Just want to publicly thank them for their review and work on this application. As the board may recall, we've appeared before you a number of times related to this particular project and this property. The property has a very long history of mining operations going back more than 45 years. Property has also been extensively farmed in its history. From the initiation of this project, even before the basic plan was proposed and approved, which was reviewed and approved by you all almost 3 years ago, on July 29, 2021, the zoning hearing examiner approved the basic plan on March 2nd, 2022, and the district council ultimately approved the basic plan, which rezoned the property in October of 2022. The vision and the goal was to create the best possible land plan while preserving and enhancing the property's unique and special environmental features. Those features consist of the Timothy Branch and Mattawoman Creek and its associated tributaries, thereby creating a very unique and special, well-planned and well-designed community. There is no doubt, as supported by the staff report and all reviewing agencies, that this infrastructure SDP, as previously reviewed and determined by the previously approved CDP and basic plan, further advance these visions and goals and satisfies all the required findings of approval today. This application and the project design results in and produces a sustainable, resilient community in a village-like setting that takes advantage of the natural environmental resources while also improving upon those features. Key to the project's goals and policies are the advances to create, improve upon, and establish 4 environmental policies and goals. First being stream restoration, second, stream and woodland preservation, third, environmental site design areas, and 4, restoration, enhancement, and preservation of portions of the property formerly in the rural tier, which is the far western portion of the property for which no development is proposed. These goals are met through the proffers made by the applicant at the time of the basic plan, carried forward as conditions, adhered to at the time of comprehensive design plan, and then further adhered to today with the infrastructure SDP. Those are to provide stream corridor assessments with the natural resource inventory, which has been done, on-site woodland conservation, which is being proposed, create new wetlands and enhance existing wetlands with adjoining meadows to focus on providing wildlife habitat, which is being proposed, provide selective woodland understory enhancements focusing on habitat and biodiversity, and provide ecological enhancement through selective ESD, environmental site design, planting motifs that replicate and increase the biodiversity of the local ecology. Now, turning to the application that's before you, as Mr. Wong indicated, we are here solely on a specific design plan for infrastructure only. That plan proposes and depicts at slide 11 in your backup, streets, water and sewer and storm drain utilities, and stormwater management facilities. Pursuant to section 27-527C, only those regulations, submittal requirements, development standards, and site design guidelines which are applicable shall be considered. The application documents submitted in support of this application satisfy the required findings of section 27-527, as well as 27-528B. Those are reflected in your staff report at pages 8 through 9, as well as on the statement of justification, which we further incorporate and adopt as testimony this morning at pages 4 through 6. All findings are met, all applicable conditions of approval are satisfied, and all referring agencies have recommended approval of this application. Now, turning to the letters of opposition that Mr. Wong indicated that are in your backup, I just want to provide some clarity. First and foremost, we agree with staff's determination analysis that for the most part, all of the points in the opposition letter have either already been addressed with the basic plan and CDP approvals, will be addressed with upcoming preliminary plan and ADQ analysis, or just not relevant to the application before you based upon the language that I read from section 27-527C. First and foremost, the opposition letter starts out by indicating that this property was rezoned through the CMA to the LCD zone. That's technically not correct. This property was rezoned through a basic plan, and subsequently the new zoning ordinance took effect during the pendency of that application, in which case the zone that was implemented was the LCD zone carried forward with the CMA. This application, this development plan is not out of character with the area. I turn your attention to the basic plan approval in your backup of page 47. As the district council determined in approving the basic plan and the rezoning, which that record consisted of 82 exhibits, 1,113 pages, all evidence that all required findings under 27-195 were met in their entirety. Those included, but were not limited to, master plan and general plan conformance, transportation facilities, a determination that transportation facilities would be adequate for the rezoning and basic plan. Other private and public facilities such as schools, recreational areas, water and sewer, libraries, fire stations, etc., were deemed adequate. Environmental relationships reflect compatibility between the proposed land use types and the surrounding land uses. Those were findings and determinations previously made by this board and approved by the district council. Turning your attention to the backup at page 11, which is the CDP resolution of approval approved by this board, affirmed by the district council earlier this year, all purposes of the zone have been met under section 27-511. All development standards have been met under section 27-513D. Compatibility with the existing land uses was previously determined at 27, which is required under 27-521A4. The CDP that was approved results in development with a better environment that could be achieved under other regulations, which was a required finding at that time under 27-521A2. The staging of development will not be an unreasonable burden on available public facilities. Again, I've already previously determined finding at the time of CDP under section 27-521A7. And the plan at that time demonstrated preservation and or restoration of regulated environmental features in the natural state to the fullest extent possible. Again, another required finding already met at 27-521A11. Your staff report for this particular application provides findings of consistency with that previous approval under the CDP. Further, and as Mr. Wong indicated, further adequacy testing will be conducted and done at the time of preliminary plan and at the time of the ADQ. Pursuant to section 27-527C, only those regulations, submittal requirements, development standards, and site design guidelines which are applicable to an infrastructure SDP shall be considered. All of the points in the opposition letter have either already been addressed with the basic plan and CDP approvals, will be addressed with upcoming preliminary plan and ADQ analysis, or are not relevant to this application before you. Finally, as Ms. Wong indicated, we did submit an applicant's exhibit with agreed upon minor clarifying edits to finding and conditions of recommended findings and recommended conditions of approval. Staff is in agreement with those edits in applicant's exhibit 1. There is substantial evidence in this record to support the findings recommended by staff, respectfully requested by the applicant to be adopted by the board today. And with that, Madam Vice Chair, we would happy to answer any questions. We do have the full assembled team with us this morning. But if there are no questions, we reserve time to respond to Ms. Gray and any further testimony, and then I would conclude at that point. But thank you for your time and consideration of this very important application as it relates to the county as a whole.
Thank you. Commissioners, are there any questions?
No.
All right, then we do. Oh, I'm sorry. No questions? All right, we do have Ms. Gray with us. Ms. Gray?
Yes, good morning. I do apologize. My camera is not coming on. I'm not sure if it's the bandwidth or if it's the first time I've used it, so I do apologize for not being on camera. Thank you for hearing my testimony today. My name is Kamita Gray, the president of the BTB Coalition. Thank you for the opportunity to offer our testimony. We are dismayed in the continuance of urban ghettoization of Brandywine. For the years to come, whether with another development and now the approval of SDP 2303 Dawson Farms. Another development of the many car-dependent sprawl developments. Brandywine is a 72% Black environmental justice community and an overburdened community due to land use. We want to go on the record that we are not against development. We support smart growth as an overall approach of development and conservation strategies that can help protect our community and natural environment and make our communities more attractive, equitable, economically stronger, socially diverse, and resilient to climate change. There appears to be a forgotten, disturbing history of the past as it relates to new construction, reinforcing segregation of the Jim Crow era. When planning and development does not include strict enforcement of inclusionary zoning principles to assure all adequate public facilities, regardless of the findings by MNCP in holding to federal laws. We understand that the applicant's states that this is all approved and condoned by our governmental agencies, it does not mean that it's holding within the federal laws. Brandywine's massive development and numerous heavy pollutant industry land use disparities that are affecting the health and welfare of its residents as a result of the chaotic growth contributing unfairly to disproportionate impacts, especially as it relates to adequate public facilities and other inadequacies as facilitated by county resolutions in conflict of the Prince George County Charter. Thank you for listening, and we have submitted written testimony for the record. If you have any questions or concerns, please feel free to contact. Thank you.
Madam Vice Chair, I did have a question. I don't believe she provided.
Okay, we had a little issue there. Let's try again.
I'm sorry. I did have a question for Ms. Gray because I do not believe in her testimony she provided her address.
Ms. Gray, are you still there?
On what testimony?
Today's testimony.
Oh, you mean my verbal testimony?
I'm almost certain that's Mr. Tedesco.
Yeah, most in all instances when witnesses testify, they provide their address, and I just don't believe Ms. Gray provided her address.
I live in Brandywine, Maryland. I'd rather not give the house address because I just had a dead rabbit put on my porch with a threatening letter.
Madam Chair, this is David Warner, Principal Counsel. Our practice in the cases that we hear is every individual who signs up to speak is required to list their address when they sign up to speak. So Ms. Gray did list an address of 8787 Branch Avenue. It's a public record, so I'm not revealing anything. She's listed the name BTB Coalition, although it sounds like she's providing testimony on her own behalf because she didn't mention the coalition. But in any case, we do have an address associated with her request to speak. So we do have that, and that's what we do in all cases.
Go back to.
I did say I was the president of BTB in my verbal testimony.
Oh, I apologize. Okay, no problem. Then that's who she was speaking on behalf of.
So just for clarification, though, Ms. Gray, 8787 Branch Avenue is not your home address. Is that correct? Or is it your home address?
Again, it's listed as 8787 Branch Avenue, Suite 17. So I assume that is a commercial address. Okay. Good.
Okay.
So I'd just like the record to be clear then, Mr. Warner, that the address given by Ms. Gray being 8787 Branch Avenue is at a significant distance from the subject property. So without providing any additional addresses, I just wanted the record to reflect that. So I appreciate your clarification of that. Just to respond in rebuttal, Madam Vice Chair, unless there's any questions, I did just want to highlight a few points from Ms. Gray's testimony. She talked about Brandywine being auto-dependent and additional developments. As you know, your scope of review of this application is limited to this application, but I do want to highlight, as previously determined, and you could take notice, the board could take notice of the fact that the Plan 2035, the county's general plan, as well as the master plan for this area, Subregion 5, identify Brandywine as one of the town centers within the county. Although this property is not technically within the town center designation of Brandywine, it is in very close proximity to the town center. That town center is in auto-oriented center. The determination of plan compliance as it relates to the general plan and this development in particular was fully vetted and determined at the time of the basic plan, again at the time of CDP. So the notion that this is auto-dependent or oriented is not an incorrect statement, but it's a statement that further addresses the planned development of Brandywine. With respect to comments about pollution that were raised during testimony, I think Ms. Gray's ire is particularly with traffic that traverses Brandywine through other parts of the state, predominantly south of Prince George's County, being Charles and St. Mary's County, that use Maryland 5 and 301 as commuter routes. But nevertheless, as it relates to this particular property, it's worth noting, and that's why I took the time to go through all the environmental goals and policies that this application and this applicant have undertaken, both at the time of CDP that were imposed, at the time of basic plan that were imposed as conditions on the basic plan, as well as on the CDP, as articulated in your staff report for this application, how all those environmental policies and goals through those conditions are being implemented here. The most significant one, and not to kind of bootstrap off a prior case today, but the woodland conservation. We are required and proposing to meet all of the woodland conservation requirements and thresholds on site. There is no off-site woodland conservation being obtained here. It is all on site. So in as much as any comments with respect to pollution, tree loss, or things of that sort, all of those things are being met on site, as well as improvements to the environmental features, the wetlands, et cetera. So ultimately, the development of this property, as has been determined previously, improves upon, enhances the overall environmental conditions, as well as meets the goals and policies of the general plan, the master plan, and specifically address other initiatives of the county with respect to its housing strategies and addressing needed housing in the county through the existing housing crisis. Notwithstanding the fact, and let me be clear, this application does not approve any of that, since we still have to do an SDP for architecture, and we are simply here to talk about the roads, utilities, the stormwater management facilities, et cetera. So with that, Madam Vice Chair, members of the board, I do feel very confident with the staff's recommendation, which we agree with, as modified by applicant's Exhibit 1, and we would respectfully request your approval of this SDP. Thank you.
Thank you. Planning board members, further discussion, and if none, we will entertain a motion.
Madam Chair, I move that we adopt the findings of staff and the finding as amended by applicant Exhibit Number 1 and approve SDP-2303, TCP2-008-2024, and variance to Section 25-122B1G, along with the conditions as outlined in staff's report and is further modified by applicant Exhibit Number 1.
A second.
I think you did second. We did not hear. Okay. We have a motion and a second. Further discussion? Commissioner Washington?
I vote aye.
Commissioner Dorner?
Vote aye.
And I vote aye. Motion carries. All right. We're now, item 9 has been removed from our agenda. And would you believe it? Through many dangerous toils and snares, the meeting is over. This concludes all items on our agenda for today. And thank you for your patience. Thank you for your assistance. And thank you to the staff. And the all-important question for me today is, Mr. Hunt, any further discussion any further items? Let's confirm that there is no further business to come before the planning board and definitely not to come before me today.
Madam Vice Chair, there are no additional business items before you all today. Thank you.
Thank you very much, and this meeting is adjourned. Thank you all for your assistance and your patience.
Thank you all. Have a good one.
All right.